Good morning. This regularly scheduled meeting of the Law and Rules Policies Committee of the Board of Architectural and Engineering Examiners is taking place in 308 Feathering Hill Hall at Vanderbilt University in Nashville, Tennessee. And notice of this committee meeting was posted on the board website on September 25th, 2017.
Roll call. Susan Ballard. Robert Campbell.
Present.
Blair Parker.
Here.
Laura Leinbold. Rick Thompson.
Here.
Brian Tibbs.
Here.
You have a quorum.
Thank you. Let's see. What's our new business, John?
Well, the only item is law rule policy changes on page 6.
Page 6, sorry.
Which, we reviewed these in most of the committees yesterday. So I think all of them, in fact, looked at these. So,
Yeah, we looked at that.
yeah, they'll look familiar to you.
Okay, let's go to page 6 and we'll review those. Highlight in here, no. There's page 6. That's it, right? Page 6.
Mm-hmm. That's it.
Okay. Oh, we talked about this yesterday, right?
Yeah.
Take my notes here. All right. We were discussing the definitions of practice and incidental practice provisions. We had potential rule changes for discussion on landscape architects. Do we need to read this into the record or just open it up for discussion?
Let's start with number 1 about definitions. I know you guys, the architects, have looked at going forward. We had a pretty good discussion yesterday, and I think the consensus was that we're somewhat leaning in that direction. But I think did we decide to get together with architects and kind of make sure, or what? I'm trying to remember.
Okay.
We had some discussion about trying to maybe get together or looking at that definition a little bit more before we really decided on anything from a rule-making standpoint, right?
Yeah, my notes were landscape architect committee that Blair wanted to seek some more input from ASLA.
Yes. Mm-hmm.
The architect committee was supportive of adopting definitions, and you liked the NCARB model language and Alabama's language, so maybe a hybrid, perhaps, of those definitions. So they actually made a motion to recommend pursuing a legislative request, a legislative proposal to adopt a definition for architecture. The engineering committee had some, wait a minute, get to it, there it is. For them, Liz had suggested that she could discuss the issue with her supervisors to get guidance on development of definitions.
Yes, and I also wrote down that Ricky mentioned that it would be really helpful in reviewing complaint cases to have more defined professions. That was mentioned, and then also competency issues were mentioned, issues with the impact on colleges, and then also restraint of trade issues. That's what I had down from the engineer discussion yesterday.
Because again, we don't want to, if we're doing a definition, we need to understand that, we don't want to have a fight every time somebody strays outside that definition if they're competent. And that's a big deal for us. And I would suspect it would be for the architects too, Rick, as you all, Brian, as you all look. We don't want to, if you guys want to do a little quick thing of grading or something around the handicap ramp, and you're competent to do that, why should that, if it's not in your definition? You know what I'm saying? So I don't want to have that argument all the time.
That would be the incidental parts, and that's what you're concerned about is what is incidental?
Yeah, but it's not just between us, it's between the people outside that we're going to be getting, oh, well, that guy, this is not specifically spelled out in that definition.
Yeah.
This is not specifically here, and look, this guy was doing this, and it may be that incidental thing that, and so it puts the onus, which I don't mind having the onus on us, it's just the constant, it takes up a lot of space when we could be doing something else, I think. So that's my big concern.
Yeah, okay.
It's not Steve's concern, but we'll act like it is.
It's my concern too.
Steve likes it like it is?
I just, yeah, I like that.
Okay.
You didn't note that I didn't agree with Ricky, though.
I can put that now.
Yeah, you're not, or
He's in favor of
you're in
definition.
favor.
But he thinks
But for a
Ricky's,
different
For a
reason.
different reason,
Okay.
okay.
he thinks Ricky's being a baby. is what he thinks.
Yeah.
Okay.
If you read those definitions, they're so general that I don't, Ricky thinks that, and he can speak for himself later on, but when we review these sets of drawings where one engineer architect stamps the whole thing, that he's gonna be able to open it up and say, well, you know, an engineer did some architecture and automatically, but they're so general, I don't think you can do that. And they're in the iPad that if you haven't taken a look at it.
You talking about the NCARB definition?
NCARB and NCES definition.
You would have to very clearly define what you mean by incidental practice and clearly prohibit architects from practicing engineering that's not included in that definition of incidental practice,
Good luck.
and vice versa, which, yeah.
Same thing's true in landscape architecture.
It would be
It's
tough.
pretty generic.
Developing a definition that clear and specific when then you get into the, like you said earlier, restraint of trade issues. You know, what if you do have an architect that's fully competent? in
Well,
certain
couldn't you come up with
disciplines
some kind of
engineering?
grandfathering thing for that?
I don't know that it would be grandfathering. I think it would just be,
Some word for it.
we gotta have something
Yeah.
that lets people do what they're competent to do, though. I mean,
Well, what they've been doing. If you got somebody that's an architect, been doing a lot of engineering, and it's against the definition, you don't want to stop that
No,
if he's qualified. Or if you,
So you said restricting trade, how did you work?
Oh, restraint of trade.
Restraint of trade.
Yeah, if you've got an architect that's fully competent in certain disciplines of engineering, and can do it now,
Right.
then you're keeping
develop
him
a
from doing it.
definition that restricts him from doing that, or her.
You mean like if an architect starts doing electrical engineering or something?
Well, and there may be architects or engineers that are classically trained in whatever.
But not professional, not a professional engineer though. They just have been doing it for a while.
No, I mean, they're professional. They're either they're a licensed architect or a licensed engineer.
But not both. Not necessarily both.
Not necessarily both, but say you've got let's say you've got a architect who for 4 or 5 years was around engineers that did grading plans. And he understands grading plans, and he understands contours and elevations. And I know that's strange to all architects in the room that you understand grades and elevations, but let's just act like that's the case. I could have a quick minute tonight, I'm sorry. But suppose you have that situation, then in the definition, that would be an engineering thing. But if you've been trained to do that and you're competent to do that, we don't want to keep you from being able to do that. Right? I mean, that's not what the intent of this whole thing is.
Is that what we would typically want? I mean,
Well, I don't know, because in my office, I have a couple of planners that, and no offense to civil engineers, but we do a better job of the contours and site planning, and then we give it to them and say, you know, don't screw this up.
Right. Fix the drainage.
Fix what you need to fix, but that's kind of a cross practice thing in our office, but we're not sealing that wrong.
Yeah.
But we certainly know how to do it, because our clients expect us to do site planning.
right.
So that's kind of a cross practice thing, but we're not stamping it and issuing it.
I understand, but
That's where the rub comes in.
but you may have something like that where somebody is competent enough to stamp that.
Yeah.
But I don't know if we really. I wouldn't want to ever have anybody in my office stamp civil. I don't care if they work 10 years with an engineer. I wouldn't want them to do it. I don't know if our practice does our coverage even cover something like
No.
that. So I don't even know why we would ever want to do that.
Yeah.
I mean, like you said, we may tell them everything to do on it,
Yeah.
but in the end, we have to let them have it. know, I don't know, it seems like that would be something we wouldn't want to get into.
So we're not doing drainage calculations, and, we know where the water needs to go, and
But we
here's
don't.
the pond, and, this building needs to be here, and this is how we want to grade it. That's what I'm saying, but you're right, we're not, I
We
wouldn't
wouldn't
stamp
want-
anything in my
yeah.
office.
Yeah, we wouldn't stamp anything that was not, like, we're trying to be a civil engineer or electrical engineer. Like I said, even if somebody in my office that worked 10 years, I still wouldn't want them to do it because,
But there are architects who do that.
Yeah, there
It's
are.
the basis of some of our complaints.
Yes,
of course.
and some of it, they know exactly, I mean, again, some of it, they've been classically trained to do that. And I use an example, if you're doing a building addition, let's say you're doing a handicap ramp on a building or something, and there's one contour you've got to go figure out, you're tying into the back of a curb.
I see.
You see, I mean, and there's some stuff like that that's going to be like that the architect is trained, maybe more trained to do it than the engineer that.
I see what you're saying.
So I mean, I'm not talking about doing a 200-acre site necessarily, but there are some of those things that we're going to, and vice versa. I mean, there may be an engineer that's a structural engineer that knows more about wall penetrations and all that stuff because that's what they've been trained to do.
Yeah.
And so they're drawing up some typical wall sections on a structural plan to make sure it ties in correctly with the whatever the plates or whatever are. And again, based on definition, that probably gets back to practice of architecture, but they know what they're doing. So I just don't want to keep that stuff from,
Okay.
you see what I'm saying? I mean, I want to make sure that we're not doing that.
Too restrictive.
Yeah, and if they're competent, they're competent. If they're not, then that's what we're here for.
Yeah. So really, one of the major concerns on this is the complaints. Where someone will complain about you doing the ramp.
Yeah.
Oversimplified, but, and then if a complaint exists and somebody has to investigate it and either say yes or no, we need to talk to this person.
And then we have a definition that says that's so restrictive or so something that we have to penalize that person because there's nothing in there that shows,
Yeah.
gives us any latitude to do otherwise. I mean, that's the dangerous, and I'm not disagreeing, I'm giving you the other side of the danger of definition. When you define something, it's just like having an employee policy manual. It's better not to have an employee policy manual, right? Because you use that to get hung by. I've been told that by 4 attorneys.
I've been hung by it too.
That's right.
I'm gonna have to go back.
I'm just telling you is what I've been told. When you have a rule, when you have a definition, that is something that somebody can use to supersede you.
I used to do employment law for the plaintiffs, so I would say on that end, you do want a policy
Yeah,
for
but-
them to exist, but maybe as the employer, I see what you're saying. But I think you guys brought up all really, really good concerns. I will say that I think it's great that you brought up the the anti-competitive concerns, but I do think since all of the other states have a definition, that I don't think Tennessee is going to get super scrutinized for seeking one out. But I do think it's a good idea to see if we can allow for competency when we are creating these definitions for those architects or engineers that could fall into either category. And so I'll bring all of these points to my chief counsel, and if the Law and Rules Committee does want to move forward with seeking out a definition, there would be a lot of consideration from our department, and chief counsel and general counsel would have their input on how to structure language and then work with the legislature for that too. So.
May I say something? In the office, and I don't know if it's a law, but we tell people if by way of education or experience you feel competent in doing something, you can do it.
It's quoting the rules.
And then if there's a question, you all bring them in and figure it out.
No, I think we're on the same page. I mean, I think we don't want to restrict by experience in education. I mean, wait a minute. It's the 3-legged stool.
Yeah.
Let me sketch that up.
Speaking of the other, he's missing his free breakfast.
Yeah, he is.
And I'm bringing up the three-legged stool in our presentation to the students this afternoon, so I'm going to leave that to Philip. Let him handle that part.
Good
You
lead.
can't get him one to carry around.
That's what he needs.
Yeah.
So the idea, the general consensus, I think, is to, yes, we want to pursue this, but we want to have further discussions, and we want to get with legal, with counsel on what those definitions might be, and how we don't be too restrictive, but be clear. You know, I think I know what I know what I need to do as an architect. You know what you need to do as an engineer. But then there are those people out there that really don't quite understand that. And I really like the Alabama language. It's very, very good. So I guess the in the report, it'd be very simply that we're gonna take this under further advisement and try to hammer out the language and let our legal department help us do that before we go to legislative.
And from a landscape architecture perspective, there are certainly areas of overlap, and that's where we would be concerned with regard to that.
Well, good
So-
point, because I can lay out a parking lot and go to the minimum requirements in the landscape ordinance and show the area that I'm going to plant, and does it need 2 trees, and what caliper are they, and I put them in there. Is that landscape architecture?
Yes, I mean, you're almost
If you're
taking
competent, if you're competent to do that,
Yeah. But
Yeah.
to me, that's a competency level, because I'm going by the rules.
Yeah.
exactly.
And I'm planting a whatever 9-foot maple, which is what they want, and
Yeah, because in a lot of jurisdictions, you're right, they say, well, we want type B screening, and they show out 30-foot spacing of a deciduous something or another. And
Yeah.
that's what that's what you put down on the thing.
Yeah.
It's for this area, you want a type A screening, and it says it here in your ordinance or whatever. So I'm with you.
And yet, a great part of what we do is we lay sites out. We set them up. We work hand in hand with the architecture side, the engineering side, but we will do the first blush on the site design, and then working together, then we take it to the next level. So we're dealing with local codes and all that kind of thing. The plantings, that's so little of what we do in our office. But we have 6 engineering firms that bring grading design to us. They want us to do the first grading, and we sit down with their engineers, and then they take it to the next level. But so there's those areas of overlap that to me are very logical, because that's what I was taught. It's what I do day in, day out. So
and that is logical. But I promise you, I would never try to do anything in Franklin, Tennessee. You would be the man.
yeah, we have a
No offense to anyone from Franklin, but I've dealt with it.
The reason I like definitions is because of not for practices that this board controls, it's for others outside of this board that have a definition, like surveying and geology.
And I think it would help the public and building officials a lot too, having those definitions, because they would know exactly they'd have more clarity regarding what services an architect could perform versus an engineer, where the overlap issues are, perhaps. But like you said, you don't want it to be too restrictive.
Yeah.
well,
An
the def-
architect's prohibited from doing any engineering work, vice versa.
right.
I'm not sure how you accomplish that, but try to figure it out.
That's why we have attorneys.
That's right.
Is this anti-competitive thing? Is this a fear we have from the state politicians? I mean,
It's a fear always from politicians.
well, it seems to be a little bit overplayed to me.
Yeah.
I mean, come on, we do what we do. I mean, you're a doctor, and I mean, it's a little bit overboard.
And I agree with you.
Restricting trade and all that stuff.
I agree. And the problem, Ricky, is the learned professions have gotten lumped in with the unlearned professions. Okay? And we, a hairdresser goes to trade school, and I'm not, I mean,
No.
they're touching my head, so I hope they know what they're doing, right? But they go to a trade school are being lumped in with somebody that has to go through levels of testing, experience, and a strenuous, hopefully strenuous education process. And so we're getting lumped in with that same group of people. And I understand some of the concern on the other side. I mean, but that plus the North Carolina dental decision, which wasn't exactly how we're structured.
No.
They picked themselves. We got picked by the governor. We're under a department of the Tennessee state government.
Yeah.
We're overseen by, and then these guys in North Carolina, or whoever it was, were just kind of a self-policing deal. And so we all kind of got lumped into that, which I'm still not sure how that happened, but we did. And now everybody's on DEFCON 2 about it.
But definitely, as a board, your primary responsibility is to protect
The public health, safety, and welfare.
Right.
Yeah.
Which is going to,
Yeah.
if people don't understand what's going on, appear to be a restriction of trade.
Yeah. I mean, restriction of trade is a consideration, but that's not your primary.
No, it's
consideration.
not, but
And I think in some of the discussions that's sort of been lost and forgotten that public protection is your primary responsibility.
And that's my point exactly. Why are we so worried about that? Because we have a clear mission on this board.
I think the large worry probably came from the recent Tennessee bill that addressed the Supreme Court case. The Supreme Court basically said that the boards were not protected for liability under the state unless the state had an active supervisor to make sure the boards were not involved in anti-competitive, anti-trade. And so Tennessee's reaction was to say, okay, well, we're gonna specifically create someone that is that active supervisor role. So do I think that you guys should have that concern in the back of your mind? Yes. Should it always be at the forefront? I think that's what the attorneys are here for. If I see something that I think is going down that path, I will tell you. If my supervisor does, he will tell you. If his supervisor does, he'll tell you. But it shouldn't hopefully get to those levels. It should kind of start with me here in the meeting with you. And if I notice something, I would certainly speak up and say, we're headed down the wrong direction here. If something were to go all the way through the channels of management, we do have that active supervisor role right now. There's an attorney that holds that role currently. So it would be up to her to decide if the board was doing anything that would be cause for a lawsuit by the FTC or the consumer. But like John said, I think your main focus should be on the protection of the public and, of course, be aware of the other concerns, but that's what I'm here for. So.
But I think that's what makes our board a good example of what boards should be. I mean, we're the gold standard, I think, versus what the dentist did. I mean,
understand.
You do, yeah.
But no, I'll shut up after this. Even though we are protected and everything's fine on that level, it takes one person getting upset about something that they perceive to be the wrong thing to run up to Capitol Hill and and either we have to fight it mercilessly or we get something jammed down our throats that does not allow us to fully protect the health, safety, and welfare of the public. And we saw it this year in this legislative session with one person getting something, and that's my overriding fear. It's not internally; it's what happens externally.
I agree. So, in summary, we're going to discuss this further as a group, all the disciplines, how we might define our professions, and then we're going to ask our legal department to help us with the language, keep us all straight, and keep us out of the ditch, as they say.
And to me, the interesting part of this is we typically don't have trouble with complaints of this type, do we? I mean, I know we have our
Some
every,
cases arise. Yeah, they
It's
but-
not like that.
but
We're not getting
it's
a
not
lot
rampant.
of
Right.
You know, we're not, it's, we get them, but, and I reviewed them, I think everybody may have reviewed them. It's pretty clear, I think, in our opinion, that we understand what that is, but then again, they either don't understand or they don't care. It's one of, it's one of the two, in my opinion. So. All right, any other discussion in regard to the definitions? None? Then can we move on to the number 2, landscape architects? Do you have comments on that, sir?
Yeah, I've got plenty of comments, but I'm looking at the wrong agenda here. But the
No, it's on page 6.
Page 6.
That was the one about whether we should require the 3
Yeah.
years
right.
under supervision of a landscape architect versus 2.
So the discussion yesterday at the Landscape Architecture Committee meeting, much the same in that currently the state of Tennessee requires 2 years of experience working under a licensed landscape architect. We are now shifting over to the CLARB type network in that for someone to take the exam, they do not have to come, or assuming all this is approved, they will not have to come to the state first. They will go directly to CLARB, go take their exam, and once they are approved and they've passed their exam, then it comes back to the state of Tennessee. As I understand it, CLARB requires, or the definition somewhat, and most landscape architects believe, it's 3 years experience. So here we have Tennessee with 2 and CLARB with 3. And so my thought was, why don't we go ahead and match these and put them together? John brought up a good point that CLARB's definition is not just as simple as I made it. There are other provisions in there where it could be 2. So I believe where we kept it is we're just going to let that stay as it is for now.
And I think the majority of our exam applicants have 3 years,
Yes.
don't they? I mean, you
But
see them
in the
more than I
industry,
do, but-
in the industry, that it
That's
seems
kind of
like
standard.
everybody knows it's 3 years.
Yeah,
So
it's really not a huge problem
Right.
for us, but.
everybody knows it's 3 years, which tells you they're not really reading the rules.
Well, I think staff, our understanding, I think from past discussions, was it really should be 3 years, but when you read the law closely, it doesn't say that.
That's right.
That's how the issue arose, that there was some confusion about that.
So for now, we're going to let that
Right.
stay as it
Just
is.
we'll leave it on the 2-year definitions for the
Yes.
state of Tennessee.
Yes.
Okay. Good. Very good. All right, we'll move on to the continuing education there. Lost my place, sorry.
The Continuing Education Committee, when they met yesterday, they made a motion to recommend adoption of the rulemaking hearing notice, which is on page 27 on the iPads. So no, I don't think any of the committees expressed concerns about the changes. They've all been discussed in previous meetings, so there was nothing new. They were reformatted a little bit. We moved some things around, but the content did not really change yet from the last meeting.
And John, in summary, this just allows for, we get rid of carryover hours and we allow for a calendar renewal or a
There's an option.
year-end renewal instead of a date of your license. Right.
Yeah.
That's just want to make sure that I hadn't missed anything.
And that's on page 27.
And I think the primary purpose of the changes is really to facilitate licensure mobility, to make it easier, provide more options for registrants to obtain their hours. Because all the national regulatory councils are really, I think all 4 of them, even the interior designers are moving in this direction, are encouraging all the states to adopt a calendar year requirement instead of having these different renewal cycles that are really confusing people who are licensed in multiple states. If everybody goes to a calendar year cycle, then it's just so much simpler to keep up with your hours. So that's the main impetus behind it, I think.
But you understand it may take a generation to kind of get that out of the way. I mean, I'm serious, because there's just people that are used to doing it on their renewal, and they kind of set themselves up for that.
What do we, was it 2021?
To phase out carryover hours.
Yeah, 2021 for phase out.
But you're going to still have we are going to have dual tracks.
Right. Architects will go strictly to calendar
You will.
year.
But we'll have kind of the dual tracks. So it'll take a while for the engineers to kind of get,
Right.
Yeah,
they'll have that option for
Right.
the foreseeable future until, if and when you decide to
Right.
mandate calendar year reporting.
Just a question, Robert. Are you getting pushback on something like this?
On this?
Yeah.
I think as long, again, as long as we allow both right now, because
Yeah.
it's just, old habits sometimes. And, I think if we allow both tracks for a while, I think eventually we'll go to a calendar year deal. And I think more people see the value in that.
Yeah.
And I've not heard anything on the carryover hours or anything.
But
Well, we got one comment at the town meeting last week at the engineers conference. We had one registrant that expressed concerns about eliminating the carryover.
Yeah.
So I think we'll get some pushback on that. But again, they've got over 2 years' notice.
Yeah.
I think is what they'll end up having.
Well, I think the thing on the carryover is real simple. I mean, there's a point where your continuing education is not fresh anymore. And, some of these people with carryover hours, that's 4 years ago.
yeah.
So you're, how current is that? And maybe it's extremely current, but, in most cases, it's not. So if the goal of continuing education is to continually educate yourself, then you would hope that you would do differently.
Well, I made the statement yesterday in that 1 year, I just kind of forgot.
Right.
Didn't keep my hours going, and I went back and used my rollover, and I'd never used it before, but that was the time I did, and it was there, kind of as a backup. But in moving forward, I think we all agree that you need to stay current, like you just said. It's a do what you got to do this year, and move on to what you got to do next year, and not worry about what you did 4 years ago, because that is not current.
Yeah.
So, but I don't think, like you mentioned, you got that one person that goes to the Hill. We're representing the whole industry, what we do, the whole profession, and I don't think I'm going to capitulate over 5 people going, I don't like that. We're not going to do that. You can't make us do that. Yes, we can.
To a point.
Yeah. So, don't want to get on my soapbox, but I did.
Yeah.
If for some reason we do see pushback on that rule, would you consider a lower time frame that the carryover hours would expire? Like you said, it was 4 years now. Would you consider something like 1 year, or is that still too complicated?
I would prefer that. We've been talking about this for 3 years.
Yeah.
It takes 4 years to get anything done like this, unfortunately. But I'm ready to roll it out now. I'd give them 2 years. I think that's more than enough time. Actually, I think that 4 years is just, why do it? We're going to let them have 4 more years of what we're doing.
You're talking about maybe putting a restriction on carryover that if they do claim carryover, the hours
How long is good?
obtained within the last
Yeah, I was
year.
saying-
Shelf life.
Oh, I see. I'm sorry.
Yes, I'm sorry.
Shelf
I was
life.
saying, I agree that I think you should pursue what you have as written, but if we do receive pushback, would you, as an alternate option, consider, like, for example, for my license as an attorney, we can have carryover hours, but only from the past 1 calendar year. And I can't reach back to 3 years ago and use my extra credits. It doesn't work like that for me. So that's all I was asking. If you get pushback on this rule, would you like me to bring another option to the table, or do you just want to run with just this?
I think just go with this. And,
Okay.
if we get some comments or something, then we'll address them and see what,
Okay.
see if they're valid or if they're just.
Mhm.
See, and I think the other thing that people don't necessarily realize that have a lot of carryover hours, or that may have gone to that thing. If you're registered in multiple states, you probably do reduce the amount of cost that you have because you're doing them all within this time frame rather than having to go satisfy this and then satisfy this because you're on a staggered. You know, and you may be caught in the middle in another state where you have to go get another 6 hours for this and another 4 hours for this. So I think it's not a big deal.
I think it cleans things up. It makes it easier to keep to track.
But it keeps, you know, on a national
Yeah,
basis.
let's do it.
Practice nationally. You know, if you do, it's easier for a professional instead of like Robert said, I've got 40 states I got to keep up with. Well, you know, 35 of them, you go 12 hours per year. It's not bad. You know, it's easy to do. You got Texas and Florida, you have to take specific classes for those. That's just part of your planning for 12 months. So, but anyway, okay.
Yeah, I don't think you need to take any action.
No, we're not taking any action.
Because it's the CD committee did.
And I think the next one is questions. And
I can
Can
summarize
you-
something to discussion. Okay. Yeah, I can kind of summarize it.
yeah, I'm on, excuse me,
So these were discussed in the committees yesterday. And the first one came from the State Fire Marshal's office. Yes, maybe I'll just read this into the record. That is it. Right here today. This came from the State Fire Marshal's office. When a design professional submits building documents to our office, our rules require that they be sealed. However, our rule, then he cites the State Fire Marshal's office rule, only references plans and specifications. It does not specifically address any other type of document. It would be helpful to us to have the A&E Board's opinion as to when a seal should be required on documents other than plans and specifications. Specifically, should the following documents be required to be sealed: change orders and addenda and field changes. We want to be consistent with the requirements. My initial thought is that if a document directs a change to planned construction and the change order or ASI is presented in a document type that must be prepared by a Tennessee registered licensee, then that document should be sealed. They're seeking input from the board on this. Yeah, I think the architects of the first question, they didn't reach a consensus on that. Is that right, Brian?
It wasn't, what is it? Everybody was the same. I felt like though that Rick and Frank were leaning more toward.
That they should be sealed?
Yeah, that they should
But
be
you
sealed.
expressed reservations about that. so-
But, you know.
Didn't reach a firm conclusion.
I could be convinced,
Okay.
but it wasn't unanimous.
Okay. And then the engineer committee discussed it as well, and they felt strongly, I think, that they agreed with the State Fire Marshal's office conclusion embedded in their question that if a document directs a change to planned construction and it's presented in a document type that must be prepared by a Tennessee registrant, then it should be sealed. I
Right.
think you agree.
That's right.
with that.
Anything that changes the design, so for instance, in a change order, even if it's, we're changing from pump A to pump B or something, or we are taking out this structural member and putting this other structural member, and it's either a cost reduction or, then we think you ought to stamp that because that is a material change to the construction document. If it's, we're gonna add 20 days to the contract or those kind of things, addenda that, you know, clarify like a bid date or something, then that doesn't have to have a stamp on it. But anything that impacts the construction documents should have a stamp.
But the change order form itself wouldn't need to be stamped, it would just need to change to the design.
Then we usually stamp our addenda just
Well,
Yeah.
yeah, a lot of times the addendum will
Maybe-
change the scope of the work.
Maybe that would make me feel better if we didn't have to stamp the forms to stamp, but like to stamp the actual change itself.
Someone brought up
Yeah.
that usually the contractor submits and he didn't want to stamp something the contractor did, submits the change order form. That's not the way we do it.
No, I mean, usually that's really that's the methodology spelled out in most contract documents, is the contractor is supposed to initiate any change order. And then,
But we normally use either the state form, which is more the AIA form, which does not, it is the owner's signature, the architect's signature. It's not, sometimes, and the contractor maybe sign it too, but it's, but now, Rick, what we were saying too is that if we don't have to stamp that form where we are saying we're everything, I would feel better about it, like what you said. But we do stamp our part of it, you know, the architect,
Change in your design.
or the engineer's change. I would feel more comfortable with that than just blanket stamp everybody else's disciplines. So maybe we're getting closer.
anything, our discussion was anything that we think materially impacts the design, any addenda or change that does that, we think you ought to stamp it. Again, if it's a bookkeeping function or administrative type thing, then no, we don't, we don't think that it should be stamped.
So we think we should seal the change orders in the addenda or field changes if it actually affects the design and
the intent of the construction document.
Yeah, because then it becomes a record document. But if it's a bookkeeping thing where
we're at 30 days.
I mean, it might be a field order where you know, it's not really a change order.
Right.
Where it's a field directive where you're working something out. Well, that's different. That's just part of the CA.
Yeah.
Because there's no document other than a piece of paper that says we did this. But your comment was not to seal other disciplines.
Yes, yeah.
Every discipline should seal their own.
Exactly.
Okay.
If you don't seal these type of documents, then how does the contractor know that it is the final document that they should use?
Well, it's kind of written into the change order information. The seal is not for the contractor. It's really is for the regulator, who's ever
Right.
jurisdiction over it. Really the seal is.
And-
So they don't. So, but as long as we are not, putting that blanket stamp over engineers and everybody else and stuff.
Absolutely.
Well, if you have a change in a drawing, there's going to be a revision date. That drawing is already sealed. You're reissuing that drawing, so that's got a seal on it. But like, go back to executing that change order that has the client's signature, our signature, contractor's signature. We don't seal those. That's
Right.
just part of the document.
Yeah.
It's part of the specification. So, I think it's pretty clear. But
Yeah, that's clear.
yeah. So.
I may have misunderstood some yesterday too, but
Yeah,
that's,
but
I'm good with that.
No, that's very clear, because everyone has to adhere to that.
Yeah.
And the change orders can be, anybody can start a change order. Client, architect, contractor, subcontractor can request a change order, so it's either yes or no. So I'm not stamping something I don't agree with, period. So on A, so is that, what I've got down is all disciplines should seal their own documents in regarding to those because they're part of the record documents.
That impacts the design.
Yeah.
The design intent. Yeah.
Okay.
On the unit price contract, you might just change the quantity in the change
Yeah,
order.
that's right.
Change the design. It just
Right.
took a few more feet of pipe or
Right.
whatever.
Yeah.
Final
We have a lot of
change
those.
orders, we do
Yeah.
that all the time.
Yeah.
Well, and that's in the normal course of the
Yeah.
project.
But that's just an accounting
Right.
thing. It's not like you're changing the impact to the design or
Yeah.
anything.
40 more units or whatever.
Right.
But you've got a number in there to accommodate those. So. Okay. All right. I think I got what that needs to be. B. Well, back up. Are we gonna? Is this gonna be a response to Mr. Cameron?
Yeah, I was going to convey.
You'll respond.
the board's
Okay.
response.
All right. All right. In B, we had a lively discussion about yesterday the trust designers. Should they seal their own drawings? That often do not, and actually think that the structural engineer of record may be doing that, because a lot of times these drawings show up in a set of drawings. I think, well, I know they do in certain instances. They put on their reference drawings, but we don't allow that, so we kick them back. So it's kind of a global issue, whereas up to a certain size of building or residence, they rely on their computer programs to size the trusses, but when it gets to a commercial level, yesterday we talked about the sprinklers, for example. The law was changed to require the engineer of record to stamp those drawings, and not some sprinkler contractor. So the question was, should we require the trust designer to seal the drawings, or is it the EOR's review stamp adequate? And I don't think the engineer of record really cares for that, but it's open to discussion.
Our discussion was no, whoever designed the trust should stamp the drawing.
And be registered in the state of Tennessee.
And be registered in the state of Tennessee.
Yeah. So I guarantee you, I've seen it, the state fire marshal's office, they do get trust drawings sealed by out-of-state engineers. That's not uncommon at all.
Yeah.
And then they wonder why they won't accept them. So. These trust manufacturers are kind of a problem, apparently.
It's not really appropriate for them to ask the engineer of record to stamp something they didn't do.
No.
And if they do, if the engineer stamps it, I think that's a problem.
Yeah. Well, we talked about that too yesterday, where there may be a collaborative effort where they are actually doing the drawings, and the engineer of record is coordinating with them and working on calculations, and is familiar, almost responsible charge, if you will, and is comfortable stamping those drawings. That's their call. But just to stamp somebody's drawings that they send you, that's a pretty major liability.
Don't we have a rule about not only, it's not just adequate to review somebody's work and stamp it, you have to perform it, and it has to be done under your
It's in the seals
responsibility.
rule, yeah.
Mhm.
Yeah.
We're under responsible charge, and it defines that.
So if we got a complaint on that, somebody could be in trouble.
Oh, yeah.
And then we've got a fire marshal tell them to do it.
Yeah. Well, it goes back to, what does that mean if the engineer is involved from the very beginning, and not just reviewing something somebody sends in, but they have knowledge of what's going on, and there's I guess a little gray area of what that
Yeah.
responsible charge is. And then if there's a complaint, then we would hear that and say yes or no.
Right.
But it occurs, and if you're just plan stamping, you're plan stamping. But if you're doing your job and you're comfortable saying, okay, we meet all the calculations, I've calculated the whatever the shear or the moment and all that stuff, and we're good to go, bam, I think that's their decision. If they're comfortable with it and are confident, I don't have a problem with it. But you're right, I think that the trust designer should be stamping their own drawings.
Yeah. Well, the only problem, the only caveat that you have on that too is our Steele's rule does say that if what you get comes from a trusted supplier. So, for instance, I'll use truss as an example. So you get a floor truss, and you've gotten them from whoever for the last 30 years.
Mm-hmm.
And it's a trusted supplier, and that's what our Steele's law says. and all I'm doing is taking that truss and integrating it into my building, then you still should have the truss designed, but that doesn't mean that the engineer should have to go back and redo that whole truss, redo that engineer record. You're using it as a auxiliary part of your design.
Right.
So, I mean, people may though get confused with that when they think, because I don't know, I'm trying to think now like a pump station. We get those stamped by a pump supplier, and that pump supplier may be in Ohio. I don't know that we require them to be Tennessee registrants. I'm not sure about that.
You know, I think the rule there requires that it's integrated into their submissions, into the design.
Yeah, but
I
all
think
trusses would be.
Well, I don't know.
You don't have
I
just
think-
a standalone truss out there. It's integrated. into
Well,
something.
I think the way the fire marshals typically receives them, I mean, the truss drawings are kind of
Probably
separate.
a shop drawing.
Yeah.
It is, yeah, it's a shop drawing, basically. It's not part of the engineer of records drawings necessarily.
Okay.
They're like separate sheets. So they're not sealed by the engineer of record. A little different. I think if they were being integrated into the drawings and sealed by the engineer, then they would need to have a question about it. But the problem is they're not integrated, they're just getting these shop drawings.
Yeah, yeah.
There's no seal on them. And you're like, what do we do with these? Yeah.
Yeah.
Yeah, this is the first time I've seen these. It must be right. You know, it's not like you worked with them for a year, collaborated, and made sure everything was right, and it was okay, because you know, I like that it's the integrated design, so. Okay. So, on that part of the, I believe that's about it, isn't it? So we're in favor of, or we expect the engineer of record not to stamp the drawings unless he is comfortable with the integrated design. But bottom line is the truss designer needs to stamp the drawings, even if they are from Ohio. Even.
How about pump stations? So it doesn't say
That doesn't have to be part of it. Well, they'll have to take the test,
All the
take
rules.
all the rules and pass the test.
That's exactly right.
Okay. I think that's it for the law and rules. Anybody have anything else to add?
Can I bring up one thing since you're
Yes.
finished with your agenda and I'm not on the committee?
This is an open meeting. Come on, Steve. Put it in.
I've heard from building official in Knoxville that a concern about, like on the building, an engineer would do the foundation design and, you know, it's approved and so forth, but then in the field, the change is made. And oftentimes the contractor will bring in a different engineer to modify somebody else's design. And I think the decision by the Knoxville building official has been that that's not appropriate. You need to go back to the original designer, which seems to make sense to me. I wouldn't ask for my opinion on that. I just heard about it, but I thought, well, that's something that might be appropriate to bring up at some point to the board. That seems to make sense to me. I mean, I thought, don't we have a rule similar to that? That the only way that can happen is if
Yeah,
the
successor
original
register.
designer is not alive or not able to modify the design so that.
Well, they might not be with the firm, or, I mean, they may have been fired.
Yes, in circumstances where a registrant can no longer provide services on a project, a successor registrant may perform work, and it explains
Yeah.
circumstances, but it starts out when a registrant can no longer provide services.
I think though part of that question is if I'm an owner or a builder, and I take exception to, everybody says, you know, things over design.
Yeah.
But if I take exception to something and I want to get another opinion, and then if I decide that that opinion and their design, and if it's sealed, is better than the previous one, I think that's the question, isn't it?
Yeah, I mean, I think you end up having to substitute I mean, I think what they're doing is okay, as long as that person, the contractor's hiring, stamps and signs another foundation. But if it's just,
It's just a.
yeah, you don't need to use 4 of these, you just need to use 3, and there's no calculation or no nothing, then I think it's.
I think the reason the contractor wants to do that is because they have a relationship with somebody and they're in the field and they need a decision quickly, and they just want to make it on the fly.
Somebody answers the phone.
Yeah.
I don't think that's appropriate either.
Okay. That's what I thought.
Yeah, yeah. No, and I'm just going to, again, I don't think it's appropriate, but if you do have that relationship, and let's say you're out in the field and you come up with a soil condition that's different than what the original foundation design was done on, and you can't get that other guy to answer the phone, you know, or he's from somewhere else, then, but I still think that whoever does the next design has to do some sort of real design that they stamp. It can't just be, you gotta do this and everything's gonna be okay. You know, I mean, that's because that does happen in the fields. You go out there and all of a sudden you dig down and it's rock where you didn't think it was rock, or there's, you know, a cave where you didn't think there was a cave.
Well, I don't do foundation design, but I would think that, you know, it's a system, not just one individual foundation. So if you're working on a building, you've got to think about differential settlement. Is this foundation stronger than the one next to it, or it's a system that you design. So
Right.
I would have a little bit of concern about, well, just making one change right here.
It affects 3 things, minimum, you know, that's kind of the rule of thumb.
Well, that's what they're doing in Knoxville. So if you know, somebody gets upset about it, we might hear it simple.
But I don't know if the rule necessarily prohibits them from going to another registrant for that change. It would have to be properly sealed by that second
That is
registrant.
specific to the current person that's sealed. That would, how you get change made if they're no longer part of the firm or whatever, but it doesn't say anything about getting another opinion and getting another sealed drawing. Unless I misread it. Do we need to make
I
the
can
rule?
read it for you if you like.
Go ahead.
Okay. In circumstances where a registrant can no longer provide services on a project, such as death, retirement, disability, contract termination, etc., a successor registrant may perform work on another plans originally prepared by another registrant. If the plans are incomplete, and in parentheses, are at a stage prior to submittal to a reviewing official, the successor registrant may not seal the set of drawings prepared by the original registrant. Rather, the successor registrant must take all steps necessary to ensure that the drawings were prepared under his or her responsible charge before sealing them. If the plans are complete and have been submitted to a reviewing official, the successor registrant may prepare and seal addenda sheets or document and seal changes to the original sheets if revisions are necessary.
But the way that is my firm, we're doing a job, I'm no longer with that firm, and that's how they make those changes from another registrant. But that's not the same thing as getting another designer to come in and show me it. It doesn't.
Some circumstances are a little different, aren't they, than
That's
what's
what,
described in the
that's my
rule there.
point, is that that's a whole different, and I didn't really think about that until you brought that up, because, that's clear for how we do all of our professions, but then what's that other, I don't think it prohibits you to do it, but you're right, how does that impact the whole system? Foundation's designed with the columns that are designed with the roof, which are designed
I
with.
guess as far as the board is concerned, as long as whatever that change, if there was a modification to design, it was properly sealed,
Yeah.
the board would be okay.
Now, the other side of that, I mean, this may be a legal question, is I'm the engineer of record, and you come in and you change my foundations, and you use your drawing, then I'm gonna withdraw.
Yeah.
As an architect, I will withdraw.
Yeah.
You know, you whoa, time out, I'm not using my drawings anymore. And that's gonna create a problem. you can't come in and modify my drawings or supplement my drawings without that proper consultation. It doesn't stop the guy from doing it, but I certainly will have an opinion on it. Yeah. Because it happened recently.
You no longer have liability. Well, that's not totally true either.
Well, you do.
Well,
Yeah. Yeah. That's the key, I guess.
I'm not going to throw another discipline interior designers under the bus, but I have a client that this designer decided that he should get something done by another architect because she knew him and liked him, and we didn't agree on something. And brought it to a meeting, and but it was sparks on the table. It wasn't pretty. It wasn't pretty neat. And that was one of those things where here's the bill, we're done, or that designer needs to go. So there's different ways of doing it. Sure. All right, anything else? We're 2 minutes over.
You can
Thanks
blame
to
me.
Steve.
Yeah. I know, so
He's not even on the committee. He made that point.
Well, see, if we'd been at the state park, I could have been out doing something, but what's
Yeah.
that do here?
Exactly.
Go to Centennial Park.
Yeah,
You go to Centennial Park.
yeah.
The Parthenow's got a nice art museum.
Hey, any of you all, especially any of you men,
Art museum.
when Kathy comes in here sometime, ask her to go get you a cup of coffee or something, or see if she can do something.
We are still recording.
Well, turn that
The meeting's not adjourned
off.
yet.
Before I thought we were adjourned.
Were you watching the news this morning about Cam Newton?
No, I won't tell you.
Yes,
some
I
more.
was watching.
So we have a motion
Oh,
on the table?
Yeah.
Adjourn.
A motion? Do we have a second?
Second.
All in favor?
Aye.
Motion carries.
What did you say?
All right.
So